you are here today for the Guardian Advocacy Workshop and to learn about how to become a guardian advocate for your child. The guardian advocacy that we're talking about is for Florida. Specifically, this workshop is for Hillsborough County because the forms and the processes can vary from county to county. They don't all do it the same way. So what we are talking about today is Hillsborough County. The forms that are online, so the packet that you got emails and the forms that online they can download are for Hillsborough County. Okay, what I would tell anybody who's going to file on their own that's here today for Hillsborough is when you do go to file, it's the Hillsborough County Clerk of Court has the forms online that are fillable PDFs. I would suggest that you use your packet to, for your worksheets and then go online and fill everything in so it's typed up nicely on the PDFs. Okay? All right, so this workshop is for developmentally disabled children who are about to turn 18 or who already are 18. And the developmental disabilities include an intellectual disability, so that's an IQ below 70, cerebral palsy, autism, spina bifida, Prader-Willi syndrome, Down syndrome, and Phelan-McDermid syndrome. Okay, so if your child does not have one of those diagnoses, then you should not be here because this is not for you. If they have one of those diagnoses or something similar, like it may be Asperger's, which is on the autism spectrum, something like that that falls under one of these categories, then this is the place for you to be. So guardian advocacy. And we're starting at the beginning. There's a how-to guide at the beginning, and I'm on that first page. What is a guardian advocate? So guardian advocacy is a process for the families or a caregiver to be appointed the legal guardian over a child who is, or a person with a developmental disability who is over the age of 18. And the most common question that we get from parents is, well, I've taken care of this child my entire life, why do I have to do this? And the reason is, when you are filing for guardianship, you are taking away some rights of that person, that adult person. And we have to have a due process before you take away somebody's rights. Just like in the criminal world, they get due process, they get to have a trial. In guardianship, they have due process. They get to have a hearing to state, yes, this person has a disability, and yes, they do need a legal guardian. This is in their best interest. So that's why this has to be done. And I'm going to go back just a little bit. So you have other options. You don't have to do guardian advocacy. We want the least restrictive means for a child. Or I keep saying child because it's your child, but it is going to be an adult disabled child. We want the least restrictive means. Okay, so the least restrictive means is signing a durable power of attorney and a living will and healthcare surrogate designation. So if they are capable of understanding what they're signing and that these documents, a durable power of attorney you can appoint somebody to be your agent. Okay, anybody over the age 18, adults, everybody that's in here should have a power of attorney and a healthcare surrogate designation, because if you get into a car accident and you're in a vegetative state, nobody's got the authority to act on your behalf. Even if you're married, nobody has the authority to act on your behalf unless you've appointed somebody. Okay, so for financial things, that's a durable power of attorney. So to help you deal with bank accounts, write contracts, anything financial or contractual, durable power of attorney is good for. And then the living will is, and the healthcare surrogate designation is for healthcare. Living will says I don't want to be kept alive artificially. If I'm terminal, end stage, persistent vegetative state, don't put tubes down my throat to keep me alive if that's the only thing keeping me alive. And 2 doctors have to certify you're in that condition. And then the healthcare surrogate designation is who you appoint to be your healthcare agent. If anybody here has heard of Terry Schiavo, if she would have had those documents in place, you probably never would have heard of her, because whoever she appointed would have had the authority to act on her behalf. But then she had to go through a guardianship. Her family had to go through that guardianship proceeding to be able to make decisions for her. So a power of attorney and a healthcare surrogate can be signed by somebody who has the ability to understand what it is they're signing, that they want this person to be appointed as their power of attorney and their healthcare surrogate. Now, that being said, if you have a child that is easily taken advantage of, then they may not have the ability to sign, because if they're easily taken advantage of, like let's say they're living in a group home and anybody could put a piece of paper in front of them and they're going to sign it, that's not going to be the best situation for somebody to sign a power of attorney and healthcare surrogate, because you're very likely going to be right back to filing for guardianship in an emergency situation if somebody is taking advantage of them or somebody else put that paper in front of them and had them sign off on it. Okay, everybody on understanding? Okay, great. So guardianship or guardian advocacy is for that situation where they can't sign the power of attorney and the healthcare surrogate, and somebody needs to be their legal guardian because, in most cases, because you've got to make those healthcare decisions. And we see this real commonly with kids that have a diagnosis of autism. If they're over 18, and they go to the doctor, and the doctor's in front of them saying, well, you know, they need a shot, they need this or they need that, and they say, no, 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 no. Well, when that adult child says no, that's it. The doctor's not going to go any further. So that's when this can be very important. And for educational decisions, it didn't used to be a problem, or not a problem, but they didn't used to enforce it as much, but now we are seeing, especially in Hillsborough County, the schools are enforcing. If that child turns 18 and there's an IEP, they won't talk to you, they won't tell you what's going on, because they don't have to, because that's the child is now an adult. So if you want to be able to make those educational decisions and decide where is this person going to live, if they're not living with you, if they're living in a group home, and if they're getting waiver services, and if you're familiar with that, if you have a caseworker you're working with, when that child's over 18, they may not want to talk to you. If you get a stubborn caseworker, they're not going to talk to you. They shouldn't be talking to you because the child is 18. So they're trying to make all those decisions with the adult disabled child. So if you want a say in that process, you need to be their guardian advocate. Okay? So this process here, what we are going over today, is so that you can file on your own as guardian advocate over the person. So there's two different: guardian over the person and guardian over the property. Guardian over the person is so that you can make healthcare decisions, educational decisions, decisions of where this person is going to live. Guardian over the property is for contractual decisions, financial stuff. All right. So guardian over the property would be, again, it's a good idea to have guardian over the person and property, especially if you have a child that's easily taken advantage of. Because the common story that we've heard in the past and that we've had clients have issues with in the past is child's living in a group home, somebody gets a hold of them and takes them to a car dealership and says, oh, you don't need mom and dad's permission. Here, sign off on all these papers. If there's no guardianship over the property, they're liable for that, for what they signed off on. So if you want to prevent that from happening, guardian over the person and property is best. In Hillsborough County, so guardianship where you file is determined by where the ward, the child, the person with the developmental disability lives. Okay, so that's the county that you have to file in. In Hillsborough County, our court only allows you to file on your own if you're guardian over the person. In other counties, they do let people file as guardian over the person and property. So if you want to be guardian over the person and property, right now, on February 16th, 2019, for purposes of this video, you do have to have an attorney for guardian over the person and property in Hillsborough County. Okay? So again, this is for guardian over the person only, so the ability to make decisions of where they're going to live, healthcare decisions, educational decisions. You're going to see in the paperwork that we fill out that the guardian advocate is only responsible for certain things, and those things are, there's an order and letters that a judge signs off it with, and that gives you your authority to act on behalf of, of the ward. But if you are, you will not have the right to, for instance, if they want to get married, you don't have that's not a right that you can take away from them. The court can say they need permission to go, they have to go back to court and ask if they want to get married. The court can put that in the order. But you don't take away their right to vote. They still do have the right to vote. If they can keep the right to drive, if they're able to, and at some point be able to get their driver's license. Those are certain things that the court will not take away automatically in a guardian advocacy. One other thing I want to point out, when you file to become your child's, the adult disabled person's guardian advocate, you do have to file an application with the court that's all about you. We're going to go through that in a minute. And you have to give, in Hillsborough County, you have to give them a credit report. In other counties, you have to do fingerprinting. And the different counties use varieties of ways to run a background check on you. So the application, in Hillsborough, the application and the credit report allow them to run a background check. You cannot be a guardian if you have a felony conviction, okay? So that's pretty much, that's going to stop it in its tracks. So as long as you're clear there, then you can move forward with being the guardian advocate. There's a whole laundry list of things you can't have been convicted of that would prevent you from being able to serve. There's some links in here for you as far as the guardian advocate statute and what it requires. There's also a link here to the Hillsborough County forms online. If anybody's watching this online, at our website at ohalllaw.com, there's a whole section of pretty much every county in Florida that does allow people to file on their own with a link to their forms and their processes. So we do have that online.